Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Today is our 52nd lecture series. Exams are nearing. Advocate on Record examinations are nearing. Some of our AOR aspirants are going to write in the next month. So, the topic which we have chosen for today is how to get success in the AOR examination 2025. So, before dealing with the topic, it is our regular practice that we recite preamble as our prayer, because we recite national anthem in government functions to praise our mother India, but to praise our legendary father, dynamic father, evolving father, living father, that is the Constitution of India. So the entire constitutional provisions from article number 1 till the end, the only one thread which runs from the beginning till the end is the rule of law. The goals are enshrined in the preamble of the Constitution. So our entire endeavor is to how to reach, how to make whatever they have stated, our founding fathers stated in the preamble, as a true reality for all our Indians. So I recite preamble. I request each one of you to recite preamble along with me, because we strongly believe that preamble our goal and preamble our soul. So we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now the topic is how to get success in the AOR examination. Before dealing with this topic, let us ask ourselves this question: why should we become an advocate on record? Unless and until we don't find the answer, we cannot proceed further. Why do we want to write an AOR examination? Why do you want to become an advocate on record in the Supreme Court of India? Because people have come from various places. Some of them from Andhra Pradesh, some of them from myself from Tamil Nadu, others from Madhya Pradesh. They want to practice in Supreme Court. Why? Reason is, it is the holy place for all the advocates. In Muslim religion, they say at least once in a lifetime they should visit the holy pilgrimage, Mecca and Medina. For Christians, they might say, let us go to the Jerusalem. For Hindus, they go either to Rameshwaram or Kasi. But for Indians, and for the more particularly the advocates, at least a person who is born and practicing in this down south, say Kanyakumari, but at least he has a dream that he wants to at least visit once in his lifetime to the Supreme Court. But we have a privileged people, blessed souls, therefore we can be in Delhi and assist and practice in Supreme Court, assist the honorable judges to evolve a law, to lay down a law for the rest of the high courts and district courts in the country. Article 141 is applicable only for the Honorable Supreme Court. High Court judgment will bind only within that state. But Supreme Court judgment will bind throughout the territory of India. Law declared by Supreme Court is binding on all courts within the territory of India. And Article 144 says all civil authorities, judicial authorities must act in aid of the Supreme Court. Even if there is no law, law is given by the Honorable Supreme Court through pronouncement of the judgments. Even Honorable Supreme Court has given timelines for the governor as well as for the President of India to decide the bills, what is pending before them. So therefore, dear friends, it is not which domain is bigger than the other domain. Recently, our Honorable Chief Justice, Honorable Justice my Lord B.R. Gave, his Lordship has said, whether legislature, the parliament is supreme, whether executives are supreme, whether the judiciary is supreme, don't ask the wrong questions. Ask the right question. What is supreme? Supreme is the Constitution of India is supreme. All the organs functions well within the framework of the Constitution. That is why Honorable Justice Krishna Iyer, my Lord, has said, even the courts have a constituency. And what is the constituency of the court? That is the nation. Who is there in the nation? We, the people of India. Our territories are there. Plants, animals, living organisms, everything is there. Who has to take care? Court has to take care. Therefore, the court's constituency is the nation. Even there are manifestos for the court also. What is that manifesto? Constitution of India. To uphold the Constitution of India is the manifesto for the courts. So how beautifully Justice Krishna Iyer has said in one of his judgments. So therefore, dear friends, to answer our query, why do you want to become an AOR? So when Constitution of India is supreme, who is upholding the Constitution? Who is the final arbiter of the Constitution? If there are grey areas in the Constitution provisions, who is the final arbiter? Whose word is final? Ultimately, it is the Honorable Supreme Court. Parliamentarians can make law with due respect to every one of them. That is the pillar of democracy. If citizen, an individual, says that it is violative of my fundamental right, that can be challenged before the court of law. That law, to the extent when it violates the fundamental rights, it can be struck down. Either the provision or the entire constitution, entire the provisions in the act or the entire act can be struck down as per judicial review, Article 13. So therefore, such a immense power, enormous power vested with the Honorable Supreme Court. And one important provision that I must bring it to your notice, Article 142 of the Constitution of India. To do complete justice, the Honorable Supreme Court can make any orders. That means sky is the limit. To do complete justice, what is complete justice? It depends upon the facts to facts. It left to the wisdom of the Honorable Supreme Court to decide what is complete justice. So therefore, dear friends, when such an enormous power is vested with the Supreme Court, but who is assisting the Supreme Court? Very important question. Who is assisting the Honorable Supreme Court to provide quality justice, to provide timely justice? The lawyers. We, the advocates, are assisting the apex court. But more particularly, in the Supreme Court, advocate on record are considered as lifeline for justice delivery system. Who has said this? Honorable Justice Suryakant, my Lord, has said this. Very recently, Honorable Justice Abe Oka, my Lord, has said, advocate on record they need to act with responsibility. Then only we can have quality justice. When quality of AOR is diluted, that means justice is diluted. Quality of justice is diluted. Therefore, dear friends, whatever we are going to assess, that may become the law of the land. So therefore, we should understand our responsibilities. To understand our responsibilities, AOR gives us a qualification. Therefore, if you want to become an advocate on record, then only you will be recognized. A person who is authorized to act and plead on behalf of party is an advocate on record. If you are only an advocate, if you get a case, you will go and hand it over to advocate on record, because every filing has to be done only through an advocate on record. E-filing will be done only in the domain of advocate on record. They have their own login ID. Appearance, online appearance only through web portal, advocate on record. Senior advocate, they are the legal luminaries. But the law says, the Supreme Court provision says, senior advocates cannot appear without the assistance of advocate on record. That is the privilege given to them. But what is the restriction for an advocate on record? You can deal with the client, analyze his problem, and put it in pleadings, file it, argue your case, and then get a certificate copy. So dealing with the client C ends with the certificate copy. C to C, it is vested with the advocate on record only. Advocates and senior advocates, where they require the presence of advocate on record, but advocate on record is a completely independent person. He can act from the beginning till the end. And even a petition is drawn, if it is filed only by an advocate on record, but still advocate on record is responsible. And he is held accountable. Greater power comes with greater responsibility. So once you say that you are an advocate on record, it comes, the root is responsibility. Fruit may be your privilege, but the roots are rooted with the responsibility. So you have to act with responsible manner. So therefore, dear friends, advocate on record, if you want to become a serious practitioner in the Supreme Court, you have to become an advocate on record. That is the answer. Now, having found the answer to become an advocate on record, what is next? Next is we have to clear that examination. So how to clear that examination? So how to get success in the AOR examination, that is the topic for today. And I would like to deal with this topic under two headings, dear friends. One is preparation. Another one is presentation. Because you prepare at your office, at your home, ultimately it has to be presented in your answer sheet. There we will not speak, our answer sheet will speak to the examiners. Whether you have studied for overnight or you have studied for 5 years, your answer sheet is going to speak. Right? So now let us talk about the preparation. How many subjects are there? There are 4 subjects. What are they? Supreme Court Practice and Procedure, Drafting, paper 2 is Drafting, paper 3 is Advocacy and Professional Ethics, paper 4 is Leading Cases. These are the 4 subjects. Dear friends, don't think that these are all 4 different subjects. That is where we commit mistakes. Sir, I have prepared for Practice and Procedure, but I have not prepared for Leading Cases. Don't say like that. They all belong to one family. That is, in Supreme Court of India is a family head under which there are 4 children. Practice and Procedure, what you study in Practice and Procedure, you can apply for drafting. What you study in Leading Cases, those you can apply in drafting. Professional ethics subjects, Leading Cases, you can deal with the practice and procedure also, leading cases also. Fine, dear friends. Therefore, see it as one soul in four forms. One soul, that is Supreme Court of India. Four forms, that is four different papers. So now, how will you approach this topic? First is Supreme Court practice and procedure, in which the constitutional provisions which deals with the Supreme Court. I will tell you the important topics, dear friends. See, we have come out with this book. I wish and pray that every advocate on record must have this book. Reason is, we have meticulously prepared this book and we have studied all the 5 years question papers and most frequently questions that was repeatedly appeared in the questions papers. We have brought it as chapter wise. So more number of questions will become chapter 1. Thereafter, second chapter, third chapter, it goes as per the number of questions. Now let me focus on the practice and procedure first. Dear friends, our research says, I am talking about practice and procedure. Number of questions, 30 questions was asked from the Supreme Court rules. Because in Supreme Court rules, dear friends, important rules are there. Powers of the registrar court, powers of the single judge, division bench, when the matter can be referred to the constitution bench. That is one set. Another set of question is order 4, which deals with advocates. Advocate on record examination, qualification, when advocate on record can be disqualified, what is this, limitations, everything is dealt in order 4. That is very important because you are appearing for AOR exam. So you should know which provision deals with it and what are your duties and responsibilities. Thereafter, jurisdictions. In writ jurisdictions is PIL. Why PIL? Because it is very often it is misused provision. Instead of public interest, it becomes publicity interest. So therefore, what are the conditions in PIL? That is important. Then appellate jurisdiction, SLP. 80 to 85% of cases are filed through SLP. So SLP format is in form number 28 of the Supreme Court rules. And order 21 of Supreme Court rules deals with SLP civil. Order 22 deals with criminal, SLP criminal. So likewise, dear friends, these are all the important provisions. You cannot miss it out. So let me tell you, 30 questions from Supreme Court rules, 21 questions from special leave petitions. 18 questions have come from writ jurisdictions. Then legal terms. This time also we can expect one of the questions may be, what is obiter dicta? What is ratio desideratum? What is stare decisis? So one legal terms might be asked. Then Contempt of Courts Act. Then rules governing AOR. This time many judgments have come, passed by Honorable Justice Ladyship Bella M. Trivedi ji and Honorable Justice Abhay Oka, my lord, has passed several judgments on responsibility of AOR. So these are all the expected questions. Then appellate jurisdiction of the Supreme Court, curative petition, transfer petition, various jurisdictions of the Supreme Court, inherent jurisdiction, 142, advisory jurisdiction. So like this it goes, dear friends. There may be a question regarding presidential reference also. So this is with respect to the practice and procedure. Drafting. Which question you can expect is definitely either SLP civil, SLP criminal. Draft, specially petition civil matter or a criminal matter. One question or two questions for sure. Then transfer petitions, writ petition. Regarding writ petition is concerned, dear friends, I want to correlate with the leading cases. Because in all leading cases, the main challenge was the constitutional validity, or is it violative of basic structure doctrine, or is it violative of any of the fundamental rights. So whatever the submissions made by recorded in the judgment, you can take those grounds also in the drafting. So generally, for example, when you are asked to draft a writ petition, you all know writ petition can be filed only when there is a violation of your fundamental rights. So what are the fundamental rights that you can bring out? Either 14 or 19 or 21 or any other religion, freedom of religion. It depends upon the facts. I will tell you one thing. Questions asked in the AOR examination has hidden answers. Very important. Answers are hidden in those questions itself. So you have to see if they are asking us, it is a violation of your speech. If you are publishing a book is restricted from publishing by the government. What is violated? Article 19(1)(a) is violated. If you are an author, and you may say that right to livelihood is also violated. So anything is, if you read keenly, you can bring out your fundamental rights violations. Bring 3 grounds or 4 grounds. So that is sufficient. See, examiners are not expecting the quantity of pages. How many pages you are going to write? That is immaterial. The quality is important. 3 questions of law, 4 grounds, that is sufficient, they are saying. So as far as drafting is concerned, dear friends, I request each one of you to at least watch the videos given in our Supreme Court website, the lectures delivered by the concerned senior advocates. 3 times, 4 times, 5 times, more number of times you are going to watch, the more clarity you will get. Because lecturers, they have highlighted the important topics. It's not mere watching. You have to write down. Yes, you are going to write by handwritten. The exams will be handwritten. So practice. And please write down everything and have your group, 3 people or 4 people. What you have missed, that will be covered by your friend. So therefore, if you have a group study, you will understand with more clarity. So watch those video recorded lectures minimum 5 times. Minimum 5 times. Because that is the base, that is the foundation based on which you are going to prepare. Minimum 5 times, because maximum 5 attempts. To restrict that maximum 5 attempts, minimum 5 times you watch, you will clear it in the very first attempt. So please watch it and make notes. From our side also, we will also prepare notes and circulate to our AOR aspirants also. We will also do it. But you are going to write exam. So you prepare on your own way. This is with respect to all the papers are concerned. And drafting generally, dear friends, I was told by some of the aspirants, those who have failed in drafting, they are having a general impression that, so we generally draft petitions every day. So we all know the SLP procedure, what are the grounds. So we go there, sit in the examination hall and read the questions. Based on the questions, we start drafting. But in my humble opinion, for reading those questions, it itself will take 6 hours. Then how can you read everything and write the answers? So there will be a different methodology for that. The different method is, dear friends, if you are asked to draft specially petition, if you are asked to draft writ petition, most of the questions are based on already decided judgments. For example, Sabarimala temple. It is already judgment delivered. But how they will produce is, in the question paper, women were not allowed to enter the temple. They will give set of facts and ultimately draft a writ petition on behalf of women's association challenging that it is a violative of their gender equality 14. So once it is said, that means already related judgment is there. So you have to watch the lecture delivered by the concerned senior advocate and you have to figure out which leading cases being referred, take out that judgment. And if you are asked to draft a petition, submissions made on behalf of the petitioner in that judgment will be your grounds. If you are asked to draft a counter affidavit, alternatively, submissions made on behalf of the respondents which got recorded in the judgment, same judgment, that will be your counter affidavit. So while reading a judgment itself, put a tabular column. Submissions on behalf of the petitioner will be your grounds. Submissions on behalf of the respondent will be your grounds for your counter affidavit. Going through one judgment will make you to prepare. So once you are thorough with, these are all the most important questions. Once you sit there in the examination hall, what you need to do? You have to cross verify whether is this a same judgment related to Sabarimala. So quickly you will have a glance and you will reconfirm once again, yes, this is a judgment. So you will go straight to what is required from the candidate. If they are asking you to refrain, restrict yourself to synopsis and list of dates and events, don't, just for sake of filling up the page, don't do the grounds, SL, questions of law. What is asked from you, that alone you concentrate, dear friends. You have to read the questions very carefully. If they have asked you to confine yourself to the question of law on the grounds alone, you have to do only with the grounds and questions of law. Just to fill up the pages, don't write list of dates or synopsis. You will not get any extra marks. What is required? Answer to those questions. This is how you can approach the drafting paper is. Is it clear, dear friends? Listen to the lectures 5 times, minimum 5 times. Write down for all the 5 times. Please do that. Nothing wrong. Write down and then identify what are the landmark judgments with respect to the reference. Take those judgments and bring those grounds in drafting. This is how I prepared, dear friends, and I secured good mark, maybe around 73 or 75. This is how you have to draft. With respect to paper 3, advocacy and professional ethics is, when you go through all the 5 years questions, definitely you can expect what will be the question for this year also. If you look at all the 5 years questions, there is a compulsory question, what are the 7 lamps of advocacy? Then what are the duties of an advocate towards the court or the client? That you can get it from the Bar Council of India website. You don't mere read the rules. In the Bar Council of India website, they have given the subheadings also for each rule. From there you can write it. So I will tell you the important topics for advocacy and professional ethics. Duties of an advocate, professional misconduct, 7 lamps of advocacy, strike by advocates. Whether do we have a right to strike? Very important. Very often we receive a message, today we have passed a resolution not to attend the courts. It happens. But are we having a right to strike? Amicus curiae, mediation and conciliation. Mediation and conciliation, what is the role of the mediator? What is the role of an advocate? Then rules governing advocates and law firms, contempt of court, special duties owed by an AOR. What are these special duties? So these are all very important questions, dear friends. And study materials are available in the Supreme Court website itself. You can download that. Everything is given, dear friends. Only thing is we have to open our eyes and have passion for this subject. So this is with respect to the advocacy and professional ethics. Coming to leading cases, 86 leading cases are there. Please concentrate more on the newly added case. If possible, correlate this newly added case with the old cases. On the last occasion, we dealt with Property Owners Association. In that case, Keshavananda Bharati case was discussed. Then Minerva Mills was discussed. Muffet Law case was discussed. So you can bring under one heading: basic doctrine, doctrine of basic structure. Another one is doctrine of judicial review, doctrine of separation of powers. Under these headings, it is already available in Supreme Court website. It was already done. I will circulate it in our group also. So all is divided which family they belong to. Most of the families, leading cases families, belong to basic structure doctrine. All are available. So therefore you can correlate, because all deals with constitutional provisions, these doctrines, and environmental laws. That is different. Arbitration and conciliation, that is different. IBC, Insolvency and Bankruptcy Code, you can bring these leading cases under one roof. So you can give different headings, therefore you can have much and improved knowledge, enhanced knowledge. You cannot read it in isolation. You have to read it together, like Article 14, 19 and 21. We have to enlarge the scope, enlarge our thinking and how to correlate. And one of our gold medalists last time, Miss Tanya Agarwal, she has said whatever her personal experience is, she didn't write the name of the cases, but whatever her personal experience, she has given us illustration, because they are not testing our memory power, they are testing our knowledge, experience, how we are applying law into that particular facts and circumstances. You can give your own illustrations. For transfer petition, if you are asked in the practice and procedure, you can say that in one of the cases we filed a transfer petition which was pending in Chennai, we wanted to get it transferred to Delhi. So like this you can share your own experience. Writ petition also, what is wrong in it? Your personal experience is a unique experience. This is what expected, dear friends. Don't merely just copy paste. This preparation for AOR journey is not a burdensome. If somebody is asking that please join us for dinner, right, and without any payment, you will feel happy. That is for only for one time. Dinner means only on that day. Thereafter you will feel hungry. But this AOR examination is something where you are compelled, given a compulsive platform to read, which is expected that every advocate should know it. So make this journey as a beautiful journey. So only not even 1 month is left out now. So you have to bring these leading cases under several headings and bring out under one headings and then start preparing. So we have dealt with practice and procedure, we have dealt with drafting, professional ethics, leading cases. You can apply whatever you have studied. For example, Keshavananda Bharati case, basic structure doctrine is there. You can apply it even in practice and procedure also. So how to correlate, how to create a link. Dear friends, the preparation is you have to watch all those videos minimum 5 times, write down everything, discuss with your friends. That will be the basis for your preparation. And whatever the questions are highlighted, focus on that. Doesn't mean that you will ignore all the topics. No. Focus on this topic. Thereafter, you can go ahead with other topics. What is important? Focus on that. And lectures are available. Study materials are available in Supreme Court website. Moreover, there is summary landmarks also. Summaries of landmark judgments. That is there in the Supreme Court website. You can see only running to 3 pages. Regarding Keshavananda Bharati, there is a portal in Supreme Court website only running to 8 or 13 pages. Entire thing is covered. Keshavananda Bharati running to several thousands of pages, covered in 13 pages. You can easily read and understand. And summaries of landmark judgments, that is also there. Dear friends, please visit the Supreme Court website. There is a column for advocates, advocate on record. If you open that advocate on record, examination is there. There you will find all those leading judgments also. Leading judgments are there. And regarding leading cases, abridged SCR head notes are given to you. This time they have specifically said those who are going to copy and write, we will not give marks. And that is not expected also. Any student, 10th standard student can copy and write it. That is not expected from us. You can read that, you can understand and write in your own way. And give headings, dear friends. For example, if you want to take away some doctrine applied in this case, like facts of the case, issues involved. I'm just telling you the overall application with respect to the leading cases. First, facts of the case. Without facts, no cases. Facts of the case or factual background. Number 2 is issues. What is the issue to be determined? Number 3, decision of the Supreme Court. Number 4, to reach the decision, what is the ratio decision time? In which there may be majority opinion, minority opinion. And you can add few headings also. Doctrines applied, legal principles applied, doctrine of sustainable development, doctrine of judicial discipline. And what are the principles? Principle of fairness, principle of legitimate expectation. Though you may be seeing it from SCR, because they would have also added in the headings, but how do you break it and write in a simple way? Principles involved, constitutional provisions are involved. You can give headings and you can see there article 14, 19, 21, whatever it is. You split up. Therefore, if there is a clarity in your presentation, it makes the examiner impressed about your answers. And most important is conclusion. My view, my personal opinion. Whether you agree with the majority, or you agree with the minority, or you agree with the unanimous judgment, or you disagree. But always please use the respectful language. I don't agree with majority view. It's not the way. I humbly disagree with the majority view for the following reasons. 1, larger bench judgment was not taken into consideration. So like that, how do you make it up? Or if you don't have any points to disagree, agree. And whatever the points that they have stated, just write down 2 things. And how do you want to evolve the judgment? For example, right to education applies only for the age group 6 to 14. Why not to 21? You can enlarge that. 21A is there. Why not to the age 21? So we can correlate. This is where the creativity is. You have to bring that creativity. Dear friends, this journey is a beautiful journey, provided you make your thought process beautiful. One of my aspirants said, I said it is a very beautiful journey, make your thought process. My learned associate said, My thought process is defective. Then another AOR aspirant said, don't make it defective, cure the defect and make it effective. So defective become effective only when you cure those defects. That is important, dear friends. And yet another, Mr. Shankar Tanti sir, my learned associate, he said we have so many competitors in our office itself because they are all going to write the examination. But my learned senior said they are not the competitors, they are our companions. The only one competitor that you will find in the AOR examination that is you, because you have a plan to rise at 5 o'clock and read, and you get up at 8 o'clock. So you are defeating your own. So the competitor is you. So therefore, dear friends, this is how you have to prepare. Don't have the fear of pausing or failing, right? Concentrate on these topics, focus on these topics. Our AOR Aspirants Academy is with you. We will also play our vital part in the preparation. We will also watch those videos and we will also try to highlight those topics. We will circulate in our group also. That will be a great beneficial. If possible, we will have our Google Meet also. Don't worry, we are with you. Your growth is our growth. Reason is we the people of India. We should grow together, learn together. Therefore, quality of justice improves. So now we have talked about the preparation part. Now coming to the presentation part. How do you present it? The presentation is first and foremost, you must have faith in your preparation. If somebody asks you to argue the case effectively, the effective argument will come only from the effective preparation. Effective presentation will come only through effective preparation. So your presentation must be based on preparation. Number one. Once you are well prepared with reference to the topics that they have said, you can write it very neatly, dear friends. Depends upon the mark. Before you start your answers, you must ask yourself, what is the time management? 3 hours. Sometimes drafting may be extra half an hour for reading everything. So before start writing anything, you must have your time frame. So 15 marks means how much time you are going to allocate for 15 marks. How much time you are going to allocate for 5 marks. So unless and until you don't do this homework, you cannot finish this paper. And don't say, sir, I know everything, but I left 2 questions. Any examination is concerned, time management is very important, both in exam also as well as in life also. Right? So time management, allocate your time with respect to the questions and try to finish it at least 10 minutes or 15 minutes before the examination. Right? So once this time management is over, now we are going to read the questions. Read the question very carefully. Reason is there may be some compulsory question. There may be optional question also. So compulsory question you cannot miss it. So read it very carefully. And see the marks, accordingly you write. If it is 5 marks means you can write 5 to 6 points. If it is 15 marks, then how will you write? First give the introduction. Your pattern has to be introduction, conclusion will be there. And this body of the answer depend upon the questions that they ask. Is it clear, dear friends? Introduction, conclusion, the body, various headings will be addressing to those questions. Let me give you an example. What is curative petition? Explain when curative petition can be filed. Whether certificate is required. If there are several questions like this, explain it with leading cases. So introduction will be there. Introduction, what is introduction? Nobody should be left with remediless when they are aggrieved. Justice must be open to all. Even judges might pass erroneous judgment. So therefore, there is a scope for remedy, that is curative petition. And what are the circumstances under which you can file a curative petition? If that is a question, that will be your heading. Circumstances under which curative petition is maintainable. Thereafter, subheading will be certificate has to be issued by the designated senior advocate. That is the question. Put that question as your subheading. Right? Thereafter, your conclusion. So body of your answers depends upon the questions asked. So once you write this, headings are given. How are you going to write, whether in paragraph? In my humble opinion, don't write it in paragraph, dear friends. Paragraphs, nobody is interested. Even you cannot read once again what you have written. Write it in a point wise. And whatever the headings you are giving, whatever the paragraph numbers are given, it should be within the margin, not outside the margin. Outside the margin, only the question numbers has to be there. Otherwise, examiners will get confused. So your marks, your whatever the points that you mention, it should be well within the margin only. Outside the margin, it has to be only the question numbers. So you are writing it in point wise. And you are going to, you have finished the first page and you are moving on to the second page. Before that, what you need to do, underline the key points. Some of our aspirants, what they do, they will think we will do it at the last. We will write first, we will do it at the last. When you are doing it at the last, you will forget what are the key points that you have written. Because you are thinking again and again and you are writing it, you will not remember at the age of, at the page of 20, you will not remember what you have written at page 1. So before you turn to the second page, highlight it. Just find out whether you have to highlight with the same pen or you can use the pencil, whatever the examiner says. So only when you highlight it, it will be easily visible to the examiners. Then they will put only the tick marks wherever you have written it. This is how. Then leading cases with respect to the practice and procedure, any cases that you have, you write that with supporting judgments, relevant case laws. So this is how it has to be for practice and procedure and professional ethics. Drafting is different. Drafting is, we have the format. With respect to the leading cases, I have told you what are the, if they are asking overall view of a particular judgment, then facts, issues, decision, ratio, decisionity, principles involved, then conclusion. This is how it has to be prepared, dear friends. Hope it is clear. So let me read just few headings alone for you. That is where the tips for writing examination. Stay confident. That is important because people will say what you have prepared is not sufficient. Sometimes you need to turn to a deaf ear. You have to listen to your conscience. Right? So please just focus on your subject alone. So stay confident. Important because Swami Vivekananda has said, if you are going to have faith in millions of God and you are not having faith in yourself, it is useless. We trust God, we believe in God because we want to have faith in ourselves indirectly. So Swami says, we are going to have faith in thousands and millions of God, but if you don't have faith in yourself, it is meaningless. Have faith in yourself. That is important. Because the history of the world is the history of few men who had faith in themselves. If you look at the history of India, Mahatma Gandhi and other leaders, those who had faith in themselves, that becomes the history of the nation. So please have faith in yourself. The only sin that we commit is we underestimate ourselves. We cannot do this. No, I cannot do this. You ask, how can I do it? That is important, dear friends. Stay positive. Your blood group may be negative, but stay positive. That is important. Time management. Answer structuring, subheadings, point wise, highlighting key points before moving on to the next page. Writing speed and legibility, dear friends. Please have courtesy for yourself as well as for the examiners. Don't write to scribble. If your life wants to be beautiful, have a beautiful handwriting, at least legible handwriting. This examiner has to read. Just like that, don't write, because your seriousness, your effective preparation is reflected in the answers. From the handwriting itself, we can understand how the mentality of that particular candidate. Right? So write neatly and legibly. And minimum 5 times watch the lectures uploaded in the Supreme Court website. That is the foundation. You are going to build the structures. Foundation is strong, you can get good marks. So the foundation is already there and you can watch multiple times. Usually in our case, lecture used to be conducted at ILI. If lecture is fixed at 4:15, we used to be there at 2 o'clock itself or 1:30 itself to occupy the first bench. And whatever they say, we never had the recording anything. So whatever they said, we wrote it down. And we had a team of first bench and we discussed with everyone and then we prepared our own questions patterns. Now it is not like that. Video is available, multiple times you can watch, but who has the interest to watch? Right? Then add your viewpoints wherever the situation is. Please have your say. That is what expected. Creativity is expected from us. You can say, in my humble opinion, this is what it is. So this is how you have to prepare, dear friends. So preparation and presentation will take you to the pass. Not only passing, you can qualify with good marks. So preparation and presentation will take you to the pinnacle in the legal profession, that is becoming an advocate on record. So I wish you all the best, dear friends. Our AOR Aspirants Academy is with you, and we want all the AOR aspirants to come out with flying colors. So wish you all the best. God bless you. Thank you so much.